Good evening, everyone. Goeienaand, alweer. My name is Nicholas Smith, and I'm the Dean of this Faculty of Law. And it gives me great pleasure to welcome you here tonight, also on behalf of Sadula Kajika, to this public lecture of the Anton Mostert Chair in Intellectual Property Law. I might add that it's the 11th edition of this annual public lecture. Of course, we missed one during COVID, but we're back on track, and it's lovely to see such a huge audience here tonight. As mentioned on previous occasions, knowledge can be shared in many different ways and on many different levels. Public lectures are only one way of sharing sometimes fairly technical knowledge with a very broad audience, and an audience which could also include eminent and very knowledgeable people and experts in the relevant fields as well. So tonight we have a very diverse audience, which is really lovely. We had a conference today, sports law conference. We have some of them in the audience. We have a wide variety of people, and therefore I hope that we will have some time also to engage with the speaker, but also with one another. I want to give a special word of welcome to our speaker, Andrew Breetzke. Yes, and Andrew is on his faculty, I'm happy to say, and he also presented earlier today at the Sports Law Conference. Thank you for setting this kind of holiday for us, Andrew. We really appreciate it. We are also delighted to have representatives here from Redco, who are the founders of the chair, and especially with a welcome to Shay, who supports the club, they are both here. Moreover, we are very pleased to welcome the representatives from Consultants, who is our partner for tonight's event. And I welcome in particular Andre Marie. He's a partner from the firm who will be introducing our speaker. Then, I want to wish welcome some institutional partners very briefly, including our Deputy Registrar of Governance, David Bang, our Head of Copyright Trademark and Short Courses, Carol Cat, Sherry and Rossi from our legal services, and then also our Vice Deans, Anita Pinar, Richard Stevens, welcome here, and of course the inaugural Chair, Professor Owen Dean. Finally, I want to give a very warm welcome to all practitioners, the media, our students, and our SRC members. I was reminded to mention them specifically, as well as all other academics present in the audience. I am very pleased to see that we have quite a few colleagues from sister faculties, including Anton from UCT, Rochelle Leroux from UCT, Rian Kluter from Pretoria, and David Letsola from UNISA. So on that note, I have concluded my formal obligations for the evening. Thank you for joining us. You are very welcome. And I now invite Andre to the front to come and introduce our keynote speaker.
But first, a word from our sponsors. Hello, everybody. It really is a privilege for us to be associated with this event. I think this lecture has become a bit of a fixture on the calendar, and I always test these things on how popular they are if you ask any of the juniors to attend after hours, and you actually have to start batting people away because some people need to stay in the office. So we've got a lot of representation here tonight, and I think that is an indication of how successful this event has turned out to be. I think the special attraction of this event, at least for me, is we don't always get to geek out on IP. We, all of us love intellectual property law, but typically at most of these events, you have to sort of cater it to the audience, which means sometimes you can't go on nice academic meanders. You have to stick to practical commercial advice. And this is one of the few times where you get to meander a little bit and explore some topics which are interesting and usually quite complex. Now, I usually skip over the marketing side of these presentations. We've got a marketing department. They always put these marketing slides in. And my thing is always just We on Sidles, we do IP, and that's pretty much it, and I move on. Unfortunately, for you and for me, I'm being checked tonight, so I have to do some marketing. So shameless plug coming. Please close your ears if you are a sensitive listener. Sidles is a boutique IP firm. We're based in Cape Town. We've got offices in Namibia, Nigeria, Cameroon, just opened one in Kenya, literally this week. We also have an office up the road in Stellenbosch. So we're growing quite quickly. We are top tier firm in every one of the metrics that sort of matter. If you follow the rules and the rankings and awards type things. That's not really what sets us apart, though. I think we've got a lot of colleagues from other firms here tonight, and I don't think I have to blush when I say we are one of the top IP firms in the country. But what makes that impressive is our firm hasn't reached legal drinking age yet, and all of our competitors, bar one or two, get telegrams from the Queen because they're all older than 100 years. So the firm is growing very, very fast, and it's been very successful for at least for 17 years. That's enough about us, I think. I'm quite excited by this topic tonight. For those of you that know me, and there are a few in the audience, I absolutely love IP. If I start talking about it, I will talk for hours. I think my sort of call sign is if I didn't get paid to do this stuff, I would absolutely do it as a hobby. I love it. I'm in love with it. Moving that aside, we have to sort of look at sport and where that fits into it. And for a lot of people in this room, I think they'll agree that sport, and maybe specifically Test cricket, is the best thing that the human endeavor has delivered to now. And I was actually going to quote from the Holy Scripture to support that statement. But the organizers asked me to refrain from religion, so you're just going to have to take my word for it. It was the Holy Scripture of Session, so I don't want to offend any Pakistan cricket fans out there. So anyway, the point I'm trying to make is I absolutely adore IP. I am in love with sport, and tonight's an opportunity to sort of put those two things together, and you just can't make me happier than that. Sport is obviously big business. All of you know that. If that wasn't the case, then most of you wouldn't have spent the whole day listening to a bunch of people talking about it. And you should always be a little bit careful when you look figures up on the internet, because it's usually not true, but at least it makes for interesting conversation. And the one number that I saw quite a few times was that the people, in other words, the internet, expects the sport industry to generate revenue of around $680 billion a year from 2028. That's monopoly money. Whether it's true or not almost doesn't matter. If you take 10% of it, it's still a staggering amount. And a PwC report identified the main drivers behind that as streaming services. So streaming services getting involved in the broadcasting side of things, but quite interesting getting involved in the sort of narrative side of things as well, which is something Andrew will touch on later on. It's just a sort of fascinating building on how we enjoy our sport. Data analysis, which is personalizing the sporting experience for everyone. It's sort of, you get to understand that athlete, you get to understand the stats around that athlete, and it just makes the experience so much deeper for you. Sports betting, which I won't go into detail in because I'm not the biggest fan on earth, but it is absolutely massive. If you look at the Premiership and all of those types of places, almost everyone is sponsored by a sport betting place, and probably a topic for a different lecture, but you can ask yourself about the morality of that. And then the growth of esport, which again is probably a topic by itself for another day. As these reports usually go, it's got a fair sprinkling of the words metaverse and AI and every little flash word that you can find. And all of those types of new technologies are just sort of amplifying these things and making sport a bigger and a bigger industry. And that sort of brings it back to what we're talking about tonight. So central to all of this and all of this money being generated is an ecosystem of rights. And the rights are used to create assets, and then the assets are commercialized through whatever method they use. Some of these rights are are not always that well defined. I know I recently attended a lecture by a sport lawyer, and one of his comments was, everyone's a sports lawyer. And I think what he was trying to say was the underlying rights are really not as well defined as you think they are. If you start drilling into the detail of what exactly those things are, they get a little bit iffy if you get too deep into it. And if you consider that the rights lead to the assets, which lead to the selling, you probably have a bit of a problem there. Our job as practitioners, or at least in my side of the practice, not all of you, is to build commercial models for the exploitation of these assets, which can be IP assets, but they're not always IP assets. They're sort of surrounding assets. And the basic premise is pretty simple. It's you identify an asset, whether it's an intellectual property asset or whatever it is, and then you commercialize it, typically through some form of either a rights acquisition or some form of a license. Easy, right? That's the recipe. If you take something like a brand endorsement deal, or I know there's a lot of people in this room that's familiar with the idea of brand endorsement, or what are the others, brand ambassador, heaven forbid, an influencer agreement. All of these things work the same. In essence, what you have is you have a contract between two parties. It's mostly a form of a license. What you license in South African context, at least, is a combination of IP rights and some form of image equity rights. You put those two things together, you build in a service element that runs parallel to that, and there you have your influencer agreement or your brand ambassador agreement. What makes it interesting for me, though, maybe just a point on the services. The services are the sort of types of things that the talent needs to do, and it gets quite granular. It's things like how often they need to post on social media, which shoes they should wear to what event, which side the Red Bull cap needs to point when the sun is that high. It really does get into that type of granular services that the talent needs to provide. So what's in essence a commercial arrangement between two relatively mature entities? Not always. I mean, some of the athletes are 17 years old. But what's in essence a commercial arrangement becomes quite difficult because the leverage or the sort of power dynamic between the two parties is so different. On the one hand, you have the brand owner or whoever it is that's contracting in this specific type of agreement. Lots of money, typically some international sport company or whatever it is. On the other hand, you have someone who has some money, but his real leverage that he has in the agreement is his fame or his talent or his marketability, however you want to sort of define that. And there's a big sort of power dynamic between those two things. If things start going south in the agreement, typically people would sue each other and it would be all nice and lovely. You can make a commercial decision on this. What happens in this case is the fame of the talent is pretty much proportional to the risk of the brand owner. And that's wrapped up as reputational risk, not monetary risk. I mean, you can sort of start drilling that down to how much money the shareholders will lose if something goes south. But that power dynamic is quite different from other types of agreements that you deal with. And we see that quite often in the sort of when things go wrong in these agreements. How do you deal with it? You can't sue someone. Social media just moves too quickly. And it literally gets down to the level where if things go south, it's the lawyer and the PR person are the first two people that are phoned. The lawyer is usually second, the PR person is first, because you need to protect your reputation more than anything else. And some of it's quite straightforward, and it's, if you take someone like, let's say, Tiger Woods or Oscar Pistorius, there are strong morality clauses in the agreement. Nike needs to get out of the one quite quickly. The other one, they decided to stay in. But it's quite a sort of one-sided spectrum argument. You know they're going to get out. You know they're going to get out in 12 hours or 24 hours. Then you've got other ones. You've got the recent one with the Chinese swimming team where Speedo sponsored the Chinese swimming team. There was a doping scandal. Now it's a little bit different because now it's a sporting organization. It's the Chinese. You want to sell your products there. Do you withdraw that sponsor? Do you still let them wear the racing suits at the Olympics? It's a little bit grey. And then you start moving away from the real sort of scandal type thing that will break an agreement, and you get into these sort of grey areas. And I actually saw one this morning. It's not a sport specific thing. It's more an influencer thing, but the principle is the same. So you've got the Hurricane Milton in Florida at the moment. I think it made landfall last night or something. And you've got a bunch of influencers who live in Florida around Disney World, and apparently Disney is sponsoring them, and they're actively advising people not to evacuate. Oh, I don't know. They didn't do a Oscar Pistorius or a Tiger Woods thing. Should you break that relationship? I don't know. Does that fit into the morality clause? I don't know. So you can see how this becomes a lot grayer than those cases that you tend to read about. Anyway, so that's really what we're doing here tonight. We're sort of exploring these rights. We're exploring the practicalities around these rights, and hopefully getting to take a little academic meander somewhere in the middle. And we're looking at how the rights are structured, how they can get manipulated, and just how they can coexist with other rights. Because again, I'm an IP guy, but these rights don't exist in a vacuum. You've got image rights, which is a bit of a swear word in South Africa, but we'll deal with it later. Then you've got things like data protection rights. All of these things start playing a role, and these things start making up this bundle of rights that's going to form the assets, that's going to get commercialized through some agreement. And to help us navigate these sort of dark waters, I'd like to introduce you to our speaker. Kudos to the team for arranging Andrew. I mean, you can see his qualifications there, but I think what makes Andrew so special to deliver this type of lecture is he can take that little academic meander with us, but he's got enough scars to show that you can actually listen to him. You can sort of follow through on the academic meander with the practical delivery. And yeah, I'm not going to rattle off your qualifications, Andrew. They're there for everyone to read. I think Andrew is speaking to us tonight specifically as the CEO of the South African Cricketers Association. And he joined the South African Cricketers Association, I think in 2012 as legal counsel. In 2019, he became the CEO. Before Andrew really sort of started getting involved in sport, he spent a lot of time in practice, almost 2 decades in labor law mostly. And that sort of started getting him into this field. We were just chatting beforehand and talking about perks of the job. And Andrew gets to travel the world and watch cricket all the time. So if you're jealous about one guy in this room, he's the one. So please join me in welcoming Andrew. Really look forward to listening to you.
Thank you very much, Andre, for that very on-point introduction. And thank you upfront to Van Zydens, because sponsorship market at the moment is very difficult. And as someone who's in that market, sponsorship drives sport, culture, arts, and evenings like this. So thank you very much. And I know I say that on behalf of everybody. And it's a special evening for me. My family's here. So Matthew, my son, my eldest son, a BA, LLB, LLM graduate of this faculty. My younger son, Christopher, is postgraduate LLB here. So it's wonderful having them here. And my long-suffering wife, Monica. Long-suffering because she now sits around the dinner table with 3 lawyers, and she asks us legal questions. And we go, well, it depends. And it depends what's reasonable. And she says, you never get a straight answer. And I'm sorry, my love, this lecture might disappoint you as well. Thank you very much to Sadula for the invitation to be here this evening. It is an honor to be here after 30 years having graduated here. In my career, I've been fortunate. I've lectured quite extensively around the country, a lot at UCT, a couple of LexisNexis labor law conferences, a lot of doping work, but never here at the faculty. And I've sort of thought that through, and I realized that I can imagine a scene where my name comes up and the dean quickly looks at the academic transcript of 30 years ago and goes, oh. So if my presence here proves one thing today, it's that Nicola never looked at the transcript, Wes Nicola, from 30 years ago. So thank you for not doing that. But it is special to be here, and it might also, that story, tell you that this probably won't be the most academic presentation you've had, but if you enjoy sport, I think you're going to find this. I'll be confident and say you will find this interesting. But in starting, let me go back to just over 30 years ago, when I was sitting in this lecture hall, privaat reg 378, toe ons nog mondelinge gehad het, contractorrecht with the most intimidating but intellectual giant of Professor Gerard Libber. And I would sit in the corner there so that he would not catch my gaze. So this is the first time I've actually sat in the front in this lecture hall. But some of you will remember that this was the textbook. De Wet en Yates Contractorrecht. En in his lecture hall. Dit was nogal 'n moeilike boek vir 'n soutie, nee, want dit was hoger Afrikaans. Okay. Ek moes nou 2 keer lees. Maar nou ja, the one thing I do remember from this book, and I don't remember much, but I remember there was a section of contract law which had created a lot of conflict amongst the academics, and there was a lot of conflicting court cases. And in the book, De Wet, in his own way, references as being a moeras van onsekerheid. Okay. And I remember that just hit me. Oh, that's such a beautiful phrase. Moeras van onsekerheid. A quagmire of uncertainty. And when I had to do this lecture, I thought, my word, that actually describes this whole issue of player IP so well. Dit is 'n moeras van onsekerheid. And not just here in South Africa. It's not just a swear word in South Africa, which image rights are. It's all over the world. Every jurisdiction sort of deals with it differently. No one quite knows what to do with it. So the starting point is, this is a moeras van onsekerheid. And then hopefully ons sal 'n bietjie sekerheid kry, but you'll see why. And you can just look at a couple of the cases. Go back to early 2000s. Catherine Zeta-Jones and Michael Douglas were married in a great celebrity wedding there in the UK. And what they did was they signed an exclusive deal with OK Magazine for photographs. You know, that soort van huisgenoot done. And they also got their guests to sign an agreement that they would not take photographs during the wedding. Okay. But the guests did, and sold them off to Hello Magazine. And Hello Magazine then went and published the photographs before OK Magazine did. And that led to this court case. And obviously, Douglas and Zeta-Jones said, well, this is infringement of our image right. We actually sold it off to OK and reclaiming damages, etc. And it went through a whole lot of courts there, and it ended up in front of Lord Lenny Hoffman. And he said something that's very definitive and profound in the sense of there is, in my opinion, no question of creating an image right or any other unorthodox form of intellectual property. So this whole idea of player IP, it's a moeras van onsekerheid, because does it actually exist? What is an image right? Should we recognize it? Is it property? No, it's not property. It's just a personal right. Okay. What is player IP? How far does it go? So these are all the questions that get thrown up. And Lenny Hoffman came and just said, there's no place for some unorthodox form of intellectual property here. In other words, some sort of player IP for the sportsman. And it's very definitive. And if you go through a lot of cases subsequent to that, everybody actually almost quotes Lenny Hoffman here. Obviously quite disappointing, because Lenny is actually South African born. He's a Sax old boy and a Sax Rhodes scholar. One would have thought better, but 50 years of a UK winter does that to a person. So it really creates this idea of people just say, no. There's no such thing as an image right. It doesn't exist. It's not going to enjoy protection. You can't, it's not property. So that's sort of the starting point. You can go across the pond to America. Tiger Woods, in winning one of his first majors, painted this picture of him, had them printed, a limited edition, and sold them off for a lot of money. And Tiger ETW Corporation is Tiger Woods' company that owns his image right and effectively trades on his behalf and his IP. And that went all the way in the courts, and there he also lost. Images or likeness cannot be protected as trademarks. Okay. And the artist's right of freedom of expression outweighs Woods' right of publicity. I mean, if they'd said the artist's right to bear arms in America, you'd have probably accepted it more than the right of freedom of expression. But be that as it may, that case has been criticized a lot. And having said that, in America, the right to publicity type of approach is actually probably the best in the world for athletes to protect themselves. But it just shows you how difficult it's been. I worked with a partner once, really someone I learned so much from, and I would go to him with a problem, and I'd say, I'm not too sure how to deal with this. Is it fair? And he'd say, what does your gut tell you? And I say, it's unfair. He says, precisely. And sometimes you look at a case like the Tiger Woods one, and my gut tells me that's unfair. But that's really what one is dealing with in terms of this moeras van onsekerheid. And so let's get a bit philosophical here. Why do people have such a problem seeing the athlete as having an image that can be property, etc., etc.? Because if we take that, Springbok, wow, we love it. We identify it immediately. It's protected. Sari own it. And Sari make hundreds of millions out of it. It's valuable. It must be protected. Last year when the World Cup was on, there were a number of breaches, escort sausages, whatever, and effectively everybody went after them. Even Rassie came out, I don't remember, he made a public statement. He said, please respect the fact that our sponsors have got the right to utilize the Springbok. If you're not a sponsor, please don't use it. And you know, when Saru start rolling out Rassie to make statements about their trademarks, then you know they're really serious. So we understand it, we respect it. But if I put Sia, easily the most recognizable, commercially valuable brand as a person in South Africa. Sia is one of the few people in South African sport whose commercial value and what he can gain and what he earns commercially far exceeds what he gets for playing the game of rugby. The only other sportsman in South Africa in the last decade who's really done that within the team context is A.B. de Villiers. What they earn on actually playing is minuscule, and Sia's in that category. But we don't necessarily see Sia in the same way as we see the Springbok. He belongs to everybody. And one of the reasons, I think, is if you look at sports IP generally, you can classify it into probably three clear areas. There's the broadcast side of it, copyright, massive generator of revenue for sport in South Africa, whether it's cricket, whether it's football, whether it's rugby. There's the merchandising, which isn't really massive in South Africa. And then there's the sponsorship type market where the image of the player becomes really important. But the image of the player is important in all of those ones. Whether it's chasing the sun as part of the Supersport agreement, or whether it's an interview with CSO, it's always there. It's not seen as something separate from everything else. And I think that's part of our philosophy of the problem of people actually getting to the point of accepting that player IP, something that exists, it should be a property that the player can trade with, for example. So with that in mind, my sort of proposition from where I'm starting is that there's legal uncertainty, as we've seen in those cases, and we'll see moving forward. That together with the pace of development of player IP in the commercial world. Okay. The last 10 years, the world of sport has moved from the game to the player at an incredible rate. And I'll touch on, won't give my story, I'll touch on how that's happened. But the person's identity, who they are and their narrative is more important than the sport. The sport is always there. And that shift in power has been so fast that the law gets left behind. And for law always needs to be relevant. And that is a real issue we have. So what happens when that pace takes over is we get to a point where the framework of the control and the management of player IP rights and how we manage it, it gets developed by practitioners. And by practitioners, I mean people like me as an administrator, legal attorneys, and financial people, CAs, dealing with on terms of player image rights and how we account for it with SARS, etc. So we're making this up as we go. And that's not really a good thing. Some of the agreements I've seen around player image rights within a licensing agreement into the metaverse are really confused, and they're drafted by reputable firms, but they're confused. Not Van Zydels. Van Zydels have got this waxed. They're all over it like a rash. So not Van Zydels. And you sort of do it, and you have the hope that the law will catch up. So what tends to happen is, when you do enter into a dispute, you almost go, gee, bloody hell, we're in dispute here. This could get ugly. Oh my word, I hope we don't have to go to court. We really need to sort this out. We don't want to end up in court here, because no one really knows what's going on here if we get to court. So, especially in a scenario where it's not just a personality right and a scenario, and you actually there's some patrimonial loss. How are you going to prove this? So that's where I'm starting from. And hopefully, in the future, we could get to a point where the legislator can move towards a point where we even have some type of legislation. I emphasize the pace. The pace of change is alarming. Whether it's the metaverse, whether it's player data, which is the next big thing, as I'll chat about. The NFTs came and went. It's just bizarre how quickly it goes. And the amounts of money we're talking about, even in the South African context, are significant. And our context is nothing near what's happening in the States, where we're talking billions. So I can't see it slowing down. It just changes. It's like IT development. As fast as IT and social media develop, so too does this area. And one of our biggest challenges as a representative of all the cricketers is how do we make sure our players are educated on this, are up to speed on this, because they can get taken for a ride, which they have been done, but also they miss out on opportunities. So let me start a story for you, which I hope you'll find interesting. Let's go back to 2003. If you recall, 95, we had the World Cup Rugby. 96, we had the African Cup of Nations. And then we got to 2003, it was the World Cup Cricket in South Africa. And you might remember this advertisement back then.
Here's your main annual day.
Extra Mondays. And had second thoughts by Thursday.
I'm going to be the coach. I'm living room. I'm sharing my expertise on playing spin.
He's favorable umpire. From no ball, it's fun, good far.
I kept it aside from the stadium stand.
Totally good ball. And finish your meetings. I staged the one concerning of the law.
All say out yours. I have went
For everyone to fall in the chair. For every round of sport.
moments. My team.
Not good sports.
Really a great ad, which was around the World Cup. Now, let me tell you the story behind the World Cup. There's always a story behind in South African sport. It's never quite straightforward. So cricket at that stage was in its infancy of professionalism. It had sort of just come out of the amateur era. And so it wasn't fully professional. There were Protea contracted players that were receiving contracts, not necessarily massive contracts. But what was going to happen was if you hosted a World Cup, my word, you got an injection of money into your governing body. So the UCB, as it was then, Cricket South Africa now, was going to really fill up the coffers from the ICC, International Cricket Council. So a major boost for cricket in South Africa. The ICC had signed a 5-year broadcast deal with Global Cricket Corporation, which was Murdoch. And I'll emphasize that broadcast deals are what make sport happen. They are astronomical, and it's why you are able to watch sport with broadcast deals. And what they did in that deal is they agreed that they would also give all the player images so that the broadcaster could then go market and use all the player images of all the players who were going to participate. So this was a significant impact, for example, on the Australian players, the English players, and us South African players. But remembering we were sort of quite naive in our infancy back then. Sean Pollock was the captain, John T. Rhodes was one of the leaders in the team, and they approached Tony Irish, who is probably the pioneer of this in South Africa. Tony is a Labour attorney, and he was basically practicing as a Labour attorney. He played hockey with John T, so John T went, will you help us? Because we're getting screwed here. Cricket South Africa is actually going to make hundreds and hundreds and hundreds of millions, and we're really going to get nothing from this World Cup. And what Tony ensured, and he did it with Dave Richardson, was they actually got the players to grant their image rights into a trust, the South African National Cricket Team Trust. It was established back then. So they actually gave away their image rights as a collective, as Protea cricketers. And they said, well, CSA, you can't tell the players to sign squad terms and use these images until you reach an agreement with us. So they can play, but there's no advertising, nothing for your sponsors. And 6 months before, Saka said to the players, whatever you do, we're not going to sign squad terms. Before every ICC event, you get to sign squad terms, which effectively give the ICC the right to use you on their advertisements for the broadcaster to use it. It's a big part of the deal. And we won't sign this unless we start sharing in the revenue. We want some of that money. You want our image, we want some of the money. And there was a big standoff. So the ICC put a lot of pressure on CSA and said, you've got to sign this. Because if the ICC didn't give over the squad terms to the broadcast in time, there were clawbacks. So there were a whole lot of moving parts here that you can see. It got to a point where Tony was actually threatened. He was told to, for those of you at the Sports Law Conference, he was told in the American way what he can do. I'll leave it at that. And he was actually threatened physically that you can't do this. We are in control of the sport. You cannot allow this to happen. And CSA did everything it could to try and divide the players, which is their standard tactic, and normally on the grounds of race, they will try and divide players. But the players stood together. If the collective stays together, it's very powerful. And 2 days before the deadline, Ali Bakr, in an urgent manner, got involved because he was actually heading up the whole tournament at the time, and a deal was signed. And that deal, not colossal, it was 7.5 million rand went to the players, which meant each player got an extra 500,000 rand for participating in the World Cup. But back in 2003, that was significant. And given that the players in those days were earning only about 400,000 rand a year, it almost doubled what they did. And that was actually the birth of Saka. That's where we started as Saka, as part of our management of the collective commercial. And we've had that deal with Cricket South Africa ever since. Fast forward to 4 or 5 months ago, the World Cup in the West Indies and America. World Cricketers, which is our body that is the collective of all the player associations, 13 countries around the world. So I sit on that board. We're a member of that. We had effectively collectivized the image rights of all the international players in those countries at an international level. And effectively, the ICC had been negotiating with us for 2 years to enter into an agreement on what squad terms should look like and an acceptance that world cricketers actually own the collective image rights and they need an agreement with us. Very acrimonious negotiation over 2 years. But we had a draft in place 1 week to the World Cup to start, significant benefits to the players, massively higher prize money, about 20 million rand just to the Proteas on ICC image rights for that tournament, so significant. The ICC a week before pull out. They say, we're not going to sign this deal, we're pulling out of the negotiation. Okay. Credible bad faith, pushed obviously by India, who don't want these deals. 6 days before that tournament, we meet with all the captains of the 13 countries, not the Indian teams, not the Pakistani teams. And those captains from all around the world sign a letter to the ICC, and we say, if you don't come back to the table and conclude a deal before this tournament, we'll play, but you have no image of ours. We do no interview after the game. You can't use us in an advert. This, obviously, 3 days before the tournament, caused a massive explosion of fighting and politics and name-calling. But 2 days before that tournament, they signed the deal. 2 days before the tournament, and we now have an agreement in place where the ICC recognizes the image rights being held at a global level by world cricketers and effectively an agreement on the squad terms. Really, I think, interesting stories of the power of the collective and how we've used the collective image rights of the players. This isn't the image right of the player in his or her individual capacity. This is the image right of the player as a collective, as part of the Proteas cricket team. Because there are 3 areas now where the player effectively trades with their image right in South Africa: individual capacity, individual sponsorship, as part of the collective as a Proteas, and then as part of the international collective. Which means, as I stand here now, our Proteas players, men and women, effectively can have up to 4 streams of commercial revenue coming into them from SA20, from being a Protea, from being domestic, from at an ICC level. Okay. Which is a massive plus for the career of these players. So it's an interesting story of how we've had to fight really hard to get a foothold, and we've done it through the collective of the players on their image rights. So how does it work in practice for us? So you have a player, he gets contracted, a grant of image rights goes across to one of our 2 trusts, National Cricket Team Trust or Professional Cricketers Trust. We then enter into agreement with Cricket South Africa. We effectively sell them the collective image rights of the players for them to go onto SuperSport, onto Betway, DafaBet, whoever their sponsors are. Sadly, not many sponsors at the moment for CSA. They pay us for that. Okay. We distribute that money to the players in terms of a formula, which is interesting, which I'll chat about over a glass of wine, and I haven't got time to go into it. We also have a deal with the SA20. So the Indian teams that own the SA20 teams don't own the image rights of the players in the collective. We own those in our trust, and we effectively trade those with the SA20, and they pay us, and the players get paid for that as well. The other side, we've assigned those rights to world cricketers. They've got to deal with Winners Alliance, a private company that is exploiting those rights in the market, and there's our ICC deal. That's a model in cricket of how the players' collective image rights are managed, which can bring in millions of extra revenue for our cricketers, men and women. About 10 years ago, Eugene is here, Eugene Hennon, hi Eugene, CEO of My Players. He's my counterpart. There are only 2 player associations in South Africa. I'm the CEO of one, and Eugene is the CEO of others. So we sort of like blood brothers and share war stories and everything. My Players effectively adopted the same model for the Springboks. So slight differences here or there, but this is effectively the same model that we have for Springbok rugby. And if you want to see where the real big money is made on this model, go over to the States. NFL, Major League Baseball, there we go. That's where we're talking billions of dollars in terms of their commercial programs. So that gives you a real understanding of how this collective works in the collective image rights of our players. And it allows us as a player association to provide incredible services to our players. We take a management fee from that, and that we actually give the services to players. Outside of that type of model, it's really standard. In football in South Africa, if you've got a contract with the football club, they own you. They own your image. They can exploit your image. You get a Premier League deal in the UK, it's the same. It's this type of clause. They own your image. They can exploit it. But if they're paying you £250,000 a week, they probably can. Likewise, in some of the English rugby contracts as well, the standard contracts they own the image. Unless, of course, you're a motherlessly powerful player who can separate his image from his playing contract. And then very often the image is owned by a separate entity, and then they enter into a separate deal, and that's why some players get significantly more money. Mario Itoje, Saracens, England, it's a bit wannabe. He effectively, Saracens got penalized and relegated because they beat the salary cap in the Premier League by actually saying, well, we'll give you, for argument's sake, £200,000 to play in the contract, but we'll pay you £300,000 for your image into your company. So they actually circumvented the cap by moving it to his image rights company, which actually was penalized by the Premier League rugby there, and ultimately the Saracens were relegated. So there's a way you can use this to abuse it. So if it's not in the collective and you haven't organized it like we have, then effectively that's the model. England cricket use this model. Australia have got a similar model in cricket. So in the cricket world, it's quite common. So briefly, I'll go through this. Let's have a bit of time. When I say player image, what is player image rights? Where do they come from? We talk about it, we throw it around. As Andre says, it's a swear word. What is it? It's almost become a collective word on its own, because depending on which definitions you go and look at, well, it's the physical image, the reputation, the identity, the voice, the personality, initials, nickname. Often we refer to them as the nil rights, name, image, and likeness. In other words, you sign an employment contract in sport together with the nil rights. Any right the player has vested in him. I quite like this definition from Barton. It's in one of the sports law books. Any right that a player has vested in him or her as an individual person, which has value because they can be licensed to a third party for commercial exploitation in the marketplace. That's quite broad. And that's very much where we're going in the market in terms of all the bits and pieces that we are now adding on. Prof. Rian Kluter, yeah, old friend of mine of over 20 years. He's an old friend, really. Was one of the first people in the sports law business in South Africa to actually put down a definition from a South African perspective, very much along the lines of the first one: personality, voice, signature, initial, or nickname. But as case law has come around in all the jurisdictions, so that definition sort of widens a lot of the time. So this case with Wayne Rooney, great Manchester United player, so you'll appreciate that. Liverpool wish they could have a player like Wayne Rooney in their history. Anyway, this case is actually interesting because he assigned his rights to a third party to exploit them on his behalf, and then cancelled the contract. And this case is actually about a restraint of trade on those rights, but it's not why we're talking about it. But they went and they said, well, let's define these image rights, and they go quite a bit further. Film, portrayal, biological information, graphical representation, electronic, animated, or computer-generated representation, going on to reputation, image, promotional performance services, or his performances. So it becomes very wide as to, gee whiz, what do you include in this supposedly small concept of image rights, which technically we're saying, well, is this what player IP looks like in its entirety? Because what's happening now is, and we're doing this in cricket, is we're looking at this next generation of rights, and Andre sort of touched on it a bit, is to, well, there's so much more. There's your heartbeat. There's how fast does your blood flow. There's how much do you sweat? What is your VO2 max? If you're a woman, how does your menstrual cycle impact you getting fit? How does it affect your performance? How hard do you actually hit the ball? You can actually track that when you hit a 6. So all this data that is now being generated because we've become so clever, well, who owns that? We're saying the player owns that. Player owns that. And FIFPro, our equivalent in football, are doing a lot of work here, that using AI technologies to create personalized biological profiles and predict how things are going to have the outcome in terms of all this information. So it's not, we've gone from the picture of the person to, you know, your heartbeat, how far you're running, how much you sweat, how hard you hit the ball. And then how you collect that data with the proper consents in place, and then how you commercialize that. Because as you said, you've got it, how do you commercialize it? Medical aid companies, life insurance companies, gambling companies want all this information, sadly. Digital media research. So we've now moved into a situation in cricket where at World Cricketers Association, we're working on a model to say, well, the player data, because cricket is full of player data. It's a player data-driven type of sport. And how do we get that into the collective, get that data, because people are asking us for it. So when I say the pace of this part of industry of sport is very fast and it's changing, this is a good example of it. You're saying, really, do they want that data? Yeah, but now we're saying to our sports people, our cricketers, you don't just give information to someone about your fitness or your health. You own that. You've got to change a mindset here. You own it because someone wants to exploit it. And that's a big part of the education around players who just naively are happy to participate in X, Y, and Z. So that's really where we're going with our next generation of rights. And FIFA are working on it, and we're working on it from a world cricketer's perspective as well. And of course, the receiver got in on this deal at some stage because the receiver suddenly saw millions of rands going through into these players' accounts and said, well, what the hell is this money? Where does it come from? And so the receiver back in 2016 drafted a guide on the taxation of professional sports clubs and players, and then also going and put a little bit of a definition in there on what are these image rights that players are using in the market from an advertising point of view, and we want our share, and so that's there. What's also interesting in that guide is this phrase: image rights are essentially personal rights, so reflecting what is in South African law, and are vested in the player as an individual person. These rights cannot be separated from the sports person and consequently cannot be disposed of or sold to another person. Lenny Hoffman would be very proud of the receiver for that one. So it's not property. It's not some unorthodox type of IP here that you can trade. Let's just make that clear, the receiver is saying. Because what has happened around the world is that effectively the Tiger Woodses, the Ronaldos, the Messis, the Federers, their image rights and everything attached to them in terms of their IP, it's owned by separate entities. And Ronaldo and Messi have gone into big trouble because when they signed up with Barcelona and Real Madrid, they effectively signed a playing contract and then they signed an image rights contract, which was effectively paid into their offshore company somewhere, some island somewhere, which was registered there, and they didn't pay tax on it. And it's really just a tax avoidance scheme. So both those guys settled with the Spanish tax authorities. So there is a large opportunity for abuse. Federer is an interesting one. All his IP is contained in Tenro AG, which is his company in Switzerland. Federer is fascinating because he was number 7 on the Sportsman's earning list last year, earning approximately $95 million in a year, and he didn't play a game of tennis. Yeah. So when I say the shift in the last decade towards the sports personality having the value, the commercial value, wow, Federer is an example of that. Doesn't even play the damn sport anymore, but is in the top 10. And effectively, he trades extensively in his company, and he just got back his RF, that trademark that's owned now by Tenro. Interestingly, remember Nike owned that, and then Nike cancelled it, but they didn't give it to him. And then it's taken a few years for Federer to actually get it. Nike didn't really want to give it to another competing company, but they were happy to give it to Federer's company. Also, then you don't want to get into a fight with Federer. I mean, Monica loves Federer. Everybody loves Federer. You don't want to have a Roger Federer versus Nike. There's only one winner there. Okay. What is interesting, though, is despite the receiver saying that, a large percentage of, and I'd even say the majority of top SA sportsmen and women, actually their image rights are owned by entities. Okay, so either the law catches up and the receiver catches up, or it just moves on away and we end up fighting about it. And I know a lot of top sportsmen who actually their image rights are registered with, are owned by companies that are registered overseas. So the law's really far behind what's happening, and the receiver similarly is far behind what's happening in terms of these image rights and this part of player IP. So I said to you, individual capacity, part of a collective, and international. Let me just show you a few more what that actually means in practice. So here, top left, clear, it's a Springbok sponsor, Thirsty. Then we have effectively Springbok rugby players, 6 of them with their image, together with the Springbok, lovely sponsorship. It works, it's a great advert. Because the image right, together with the IP of Cricket South Africa or SARU, is what makes these deals. We work very closely with them. It's not like we work separately. You have to combine the two. Bottom left, Sia, Luno, personal sponsorship, no SARU IP. It's his own deal. Top right, Temba Bavuma, it's the same. There's a New Balance and a Take-A-Lot deal, got nothing to do. It's a personal sponsorship in his individual capacity. Here we have MRF bats, 2 of the greatest batsmen of their generation, A.B. de Villiers and Kohli. Significantly lucrative sponsorship deal this, because if you are doing commercial deals in India and cricket, you are really dealing in big money. MRF. Anybody know what that stands for? It doesn't stand for My Reliable Friend. Sure. Madras Rubber Factory, the biggest tyre manufacturer in India. If you have a bat and you manufacture a bat, you are entitled to have the emblem on the bat in the front of the bat. So if you're sponsoring Tendulkar and all day he's batting, my word, you're getting good coverage on that bat. But you can't, as a third-party sponsor, as a company, put that on the front of the bat. That's contrary to ICC regulations, which is why you'll see often batsmen, when they reach 100, they turn the bat around and they hold it up like that, and you'll see there's a little sponsorship sticker there. They can do that. So what companies in India do is say, well, if we can't do that, we'll just start a bloody bat factory, which is what MRF did. So MRF is actually Madras Rubber Factory. It's one of the most significant bats in the world now. So that's an individual sponsorship for AB, which was very lucrative for him, and Kohli within the Indian market. Amul, just an interesting point, not necessarily on image. If you again, in cricket, India is colossal, absolutely colossal. Amul are an Indian agricultural company that have sponsored Cricket South Africa and the Proteas men at the ICC events. They don't really care that Amul is irrelevant in terms of agriculture in South Africa, but they have. Indians have a relationship with Rabada, with Quinton de Kock, with Heinrich Nortje, etc., etc. So they're willing to spend 20 million rand to sponsor the Springboks, even though it's got nothing Proteas rather, even though it's got nothing to do with South Africa. But if you go to India and you're sitting in your hotel and you turn on the TV, there'll be an Amul advert, and there you see KG and Quinton de Kock speaking Indian. It's quite humorous. That's one on the bottom right is Mignon de Priya. That's a Momentum sponsorship. Mignon de Priya, although it's just her. Proteas Regalia, that's an official sponsor. That would be part of our deal. So and effectively that's on the basis of which we pay our players through the commercial program. To help our players, education of players has been critical. So we contracted a company called Moonsport, and they embedded software into the social media pages of our Proteas cricketers, by consent, obviously. Couldn't do it otherwise. And what I'm going to show you here, what we did was, it was for a year, and then we went to each player to show them. You need to understand the power of your image and the power of your social media, because they don't. Sportsmen don't. Some do, but you also need to educate sportsmen. And this, I asked Heinrich if I could use his, and he said, yes, I'm using it with his consent. This was Heinrich Nortje. For a year, on his social media, just using social media like you guys will use social media, they track it as to where it goes in the world, where it goes in India, where it goes in America. and they put a valuation on it at 421,000 Rand was his value for the year. Not a lot of money, but not insignificant. But given that it's money you don't even know is there, then it becomes quite valuable. His activation value was actually only 3,509 Rand. So he only earned 3,500 Rand from that. Instagram, by the way, is where it works. Facebook and Twitter, what's it called now? X. Actually, I'm not good for sports people, but Instagram is very good. And the one that got him 3,500 Rand was one of our sponsors. We sponsored by Momentum Health. And he posted this, and it was, Momentum's app makes checking my medical aid benefits or statements quick and easy. Only with Momentum, #protest. Great. And we pay him 3,500 Rand, 500 Rand from it. So that's got a little value. So Momentum are happy. They get a tweet. Momentum are a sponsor of Saka. Did I tell you Momentum Health are a great sponsor of Saka? We're very happy to have Momentum Health here. They would be a good partner for Van Sidels. You're also a very good IP code. Guess what business I'm in? So that just gives you an illustration of how it can work for Heinrich. And so when our protest men specifically, a lot of them, their wives have had babies recently, you will note they tweet. They say, thanks Momentum, everything went well, easy admin, but we pay them for that. Momentum love it. What COVID destroyed the market of please come and cut the ribbon at the opening of our new store. No one's interested in that anymore. All they want is social media posting as sponsors. So it's a new world we live in terms of that. That's one thing COVID did. It changed that totally. This was his highest performing post, but he didn't get any money for it. But he took a picture of himself and his wife in Abu Dhabi having a Fanta in the sea after one of the games, and he wrote Fanta and chill. And somewhere there's 26,000 people liked it. And that was worth 33,000 Rand. So Fanta on that day got 33,000 Rands worth of publicity, of marketing, and he didn't even know it. So you try and educate the player and say, you know what, you actually gave that to them for free. You need to understand the value you have on it. And his worst performing post was 110 Rand because it was on Facebook and it was not a good picture of him bowling. But anyway, this was obviously much more comprehensive for the player, but you've got to understand, if you're in this market and this market's changing so quickly, there's a value to your image, there's a value to what you are able to do with it, there's a value on social media, there's a massive value on Instagram for the player. So that was Heinrich in terms of putting that together. And just where it's going further, top left, the metaverse, licensing agreements into the metaverse. Effectively, you can go into the metaverse, go into a stadium, you can meet your sports star, you can shake his hand, you can walk with him to the store, you can buy his replica shirt. The next 3 days later, the replica shirt will actually arrive at your physical door because you bought it online with your sports star. You can then walk onto the field and play a bit of cricket with your sports star, etc., etc., etc. Those are licensing deals. Fan craze and Rari started the NFT craze in cricket, non-fungible tokens, which are effectively digital depictions of the player with data on them that sit in the blockchain. My word, it sounds like gobbledygook, but they spent hundreds and hundreds of millions of dollars on this. But it is an industry that has fallen flat. Dream 11 do fantasy leagues where they needed player image rights worked in there. This was our first deal with Winners Alliance a few months ago at the top right. An online cricket game where they are now using the collective of the player image rights, and our players will receive money for getting used in those games. Bottom left, FIFA, that licensing agreement is worth billions of dollars. That's probably the most successful game. I think $1.6 billion last year. Probably the most successful. And they've also started with tennis players. Now, tennis players are starting to organize collectively outside of the ATP to create their own commercial value. Just illustrating the pace of how the sports person is becoming the focus of the future outside of the game. The future too, everybody wants the narrative, the behind the scene. These are all licensing agreements. Chasing the Sun, the best example in South Africa. We all love Chasing the Sun. We heard words we hadn't heard a lot of before. That's effectively in terms of Eugene's commercial deal with Saru relative to SuperSport. But as for these others, Formula One, the drive to survive is they attribute the fact that the average age went from 44 to 32 of people who watch Formula One. The viewership has doubled in America based on Drive to Survive. But what's interesting, it's not about the sport, the focus of these. It's about who's the person behind. It's the sports person. It's the tennis player. It's the golfer. And that's where the revenue is. So how do you make a sport big? You find the sports personalities and you develop that. Okay. So Ronaldo went to play in Saudi Arabia, not because he's 38 and still a great football player. It's because his image is the most known image in the world. And once he landed in Saudi Arabia, a whole host of countries signed up broadcast deals to broadcast the Saudi League. The same, Messi went to America, and each MSL team in America is contributing to Messi's salary because that's what gets the broadcast deals, that's what gets the viewership. So it's really interesting to see how the players have become the focus and these stories. So if you told Donnie Craven that, you know what, Donnie, one day there's going to be a program on TV and they're going to show 180 kilogram Springboks cry on TV, he would have said, never, can't even. But we cried with them. So it just shows you the power of the sports person and how this Breakpoint is actually ending. They're not doing another series because there's not that much interest in it. That goes down to personalities. Have to be a bit honest. Tennis maybe just doesn't have the personalities at the moment. So it's not that easy. Whereas in the Formula One, those guys are all a bit of arseholes because they have to. That makes for good viewing. And likewise, if you watch sprint, you're going to sort of not like some of the people you see, and that's exactly what they want. So that's very much where we are now. So what happens when they breach us? So this is where it's really, really difficult and tricky because, as Andre said, image right is a swear word. I've told you that Lenny just says, well, you're not going to recognize this. This is an IP. It's not property. How do you enforce it? What do you do? And it's interesting to see how we deal with breaches and what breaches we've had. A few years ago, 10 years ago, Unilever put out a Shield Facebook program, over a couple of weeks, a promo called High Sweat Moments, appropriate for Shield, High Sweat Moments. And what they did is they put Dale Steyn in. Now, that picture of Dale Steyn, his image in the Protea, part of the collective because it's in the Protea, and they had no agreement with Cricket South Africa. Likewise, there you see Graham. As soon as you can identify the person being in the Protea, there's a problem there. They have no agreement with Cricket South Africa to utilize that. Now, why you have to be so hard on these breaches is because the other sponsors who are paying you a hell of a lot of money for that right. So if you're not hard on them, the other sponsor says, why the hell am I paying you 100 million if you're just allowing these guys to put Facebook pages on? So we went very hard at Unilever at the time, and that's us and Cricket South Africa together because both our image and their IP has been utilized here. And very often there's an agency involved and everybody's passing the buck as to, well, how did this happen? And effectively, we went hard at them for quite a lot of money and you settle it. You don't want to end up in court on these things. You settle it and settle it very lucratively because you have one significant advantage as well. It's the same, I call it the Federer effect. Nobody really wants to get into a legal dispute with you because you're the players. And the players actually always win, said like a true trade unionist. The players always win, especially the players sit together. So that was settled. This was a Puma advert. This one's an interesting one. So when is something in the collective as a Protea? Well, you can be an individual, like the Mignon picture where she's wearing her Protea's kit, clearly a Protea. Or if there are three or more of you together as Protea players, you are identified as a Protea player. So here we have Temba, Stian van Zyl, AB Faf, and Dane Pitt. They're all sponsored by Puma. So Puma said, well, stand together, guys, and we'll take a picture of you and we'll put a great ad out. The problem is, as soon as there were three of them, they're the Proteas. Doesn't matter that they're all Puma. This was a difficult one because what Puma South Africa do is they just refer it to Germany. And then you get letters from German lawyers saying, we don't understand why this is a problem. But eventually we got a good outcome. This is just a Facebook page of Adidas giving their goods to three Proteas, KG, Dean, and JP Germany. That's JP's wife. Three together. Doesn't matter that they're not in Proteas kit. That identifies as the collective. It's Proteas cricketers, and would take action there. And as recently as Sunday, there was an article in the report about Sportbot, which is a new business about certificates for sport people. I'm not going to get into the merits of the business. I don't quite understand it. But I went onto their webpage, and there I found these two pictures. So they've got no right to utilize the image of the player in their collective as part of the Proteas. So that's just unacceptable. It's hard to believe that a company that's actually marketing itself as someone that's going to promote players doesn't actually understand how this works. It's like a plumber who doesn't know where the toilet is. So these happen all the time. So I have someone in my office, and part of his job is to look for this all the time, because we've got to protect our sponsors on that. And we also have a contract internationally with a company called Copyright Integrity International. And what they do is they trawl with their algorithms through the internet and social media, and they find these transgressions where people are utilizing it. So that in itself is a whole industry. This one's quite an old advert, but this is a good illustration of how the model works. The beer behind our boys, SA Brewery sponsors all three of those teams. Obviously, the three Protea cricketers there, so it's JP, Graham, and Lonwaba Tsotsobi. They are there on the grounds and basis of our collective agreement, our commercial agreement with Cricket South Africa. So Cricket South Africa can allow SA Breweries to utilize the player images there. SA Breweries also sponsored SAFA football, but they've got no deal on the player image. So Stephen Pienaar there at the top, he was probably playing for Everton at the time. That's his employment contract. He's got no contract with SAFA, but they used his image. And he effectively took legal action against them. SA Breweries went to SAFA and said, hey, what the hell? We sponsor you. Stephen Pienaar plays for you. And they had to say, well, yeah, actually, but we've got no agreement with him that you can use his image. And that was significant. It was quite public. It was in the papers. He sued for 5 million. It settled for an amount. But a good illustration of how the collective works, because here the Springbok rugby players would be similarly in a collective. So there you've got two teams who've got a collective agreement on a commercial basis for the player image rights to be utilized collectively, but you've got soccer players who are not. So effectively, Breweries made an error there in not understanding that as well. So how do we protect these rights? This is where it gets a bit messy, interesting, technical. And you go around the world and look at how different countries look at it. America's probably, and I'd be interested to hear what some of the academics say, is probably the one where it's the most successful to protect these rights for players. They've got a right to publicity, as they call it in America. It's a common law right, but it's also in the States through statute. New York was the first to adopt it. It's the right of the individual to control his or her commercial value and exploitation, picture or likeness, and prevent others appropriating for their commercial benefit. Okay, so is a plaintiffs identified, defendant gets benefit, there's no consent and there's injury. And there are a number of cases in America where celebrities specifically have been successful. This came up, it's quite old, 1953. And in 1953, baseball was big and chewing gum was big. And if you bought a chewing gum, you got a baseball card with the player's image. And this company, Halen Laboratories, they effectively had the right that signed up a number of players to use their image on baseball cards that you got when you got chewing gum. It was so successful, Topps Chewing Gum went and also signed up players, some of the same players. And effectively, Halen Laboratories took them on and said, you can't do that. And they said, yeah, but they're just players in the public domain. And effectively, the court found in favor of Halen Technologies and said some things that are quite interesting in terms of the wording. It introduced this right to publicity, saying this right was deemed to be a valuable, exclusive right arising from the player's images, which could be licensed to others for commercial purposes. Players were found to grant them a proprietary interest in it. So we started to talk about the words that I want to start hearing, a proprietary interest, way back then in 1953. So you can go through, in the States, there are a number of these cases, despite the Tiger Woods case, where effectively the individuals do enjoy protection there through the right to publicity. The Midler case is just a nice case because that was Bette Midler refused to give a voice to a Ford commercial. So they got one of the backup singers to pretend to be Bette Midler and do a voice. And she successfully took action on the basis that, well, it might not have been my voice, but it was a likeness of my voice. It just shows how they were able to expand it. If you go to the UK, well, obviously there's Lord Lenny we've got to get past in the UK. It's actually been quite tough for celebrities to enforce these rights in the UK. That middle case, Langstad versus Anabas, was actually ABBA. Way back in 1977, there was a company that started producing pillowcases with ABBA on it. And ABBA took action. And effectively, they lost the case because one of the reasons being that, well, for passing off, you've got to have goodwill, misrepresentation, and damage. And effectively, you have no commercial interest in that. No one's going to assume it's you because you don't manufacture pillowcases. And again, your gut just tells you that role. Passing off in the UK, it's a separate tort. It's different to our passing off. But then Irvine versus TalkSport 2003, Eddie Irvine, the Formula One driver, effectively was used in his image to advertise effectively a talk show in the UK. And that was one of the first cases where they said, he has a commercial interest in protecting his image, and he was successful. Robin Fenty versus Arcadia, he's probably the first celebrity in the UK who got it right to protect herself against the use of her image on a shirt. Do you know who Robin Fenty is? Rihanna. Yeah. Just don't say you don't learn things in this class. Rihanna. Robin Fenty is Rihanna. And effectively, the thing that sold it for the court was, well, Rihanna had her own clothing empire. So there was clearly an interest for her and damage for her because she had her own clothing brand, which could be associated. So it's interesting to see these different jurisdictions, how they deal with it in a different manner. The island of Guernsey, I put this in here because it's quite interesting. They sort of saw a gap in the market. So 2012, they passed an ordinance which effectively allowed you to go there and register your images as you could have a registered personality. If you read about it, they sort of thought all these sports people were going to come to Guernsey and all register and bring all the business, but it hasn't really worked. But it's a novel idea for Guernsey. If you start going to the continent, Germany, Italy, it's very much more like us. There's a personality right that we understand from a common law basis. But even there, they've evolved to say, well, there can be some commercial interest attached to that. India also recognizes a right to publicity and passing off, but I pick up on this case, Digital Collectibles versus Galacticus. It's last year, because in the context of cricket, this is a really important case. You need to understand, ladies and gentlemen, that when it comes to cricket, India is everything. Cricket is the second biggest sport in the world by viewership after soccer because of India. When India come to South Africa to play a cricket match here, a T20 is worth $8 million US. So in a week when they come in November, they're going to play 4 T20s. Cricket South Africa will make 600 million rand. Okay. India control the world of cricket. Last year, the ICC determined how they were going to slice up the ICC revenue. India are getting a massive share of it. Ireland and the West Indies wrote to the ICC and complained and said, well, that's a bit unfair that they're getting so much. The next day, Ireland and the West Indies got a letter from the West Indies and said, well, our team's very busy. We're not sure we're going to be able to tour there next year. The next day, Ireland and the West Indies wrote to the ICC and said, we withdraw our objection. In Cricket South Africa, effectively for that tour that happened last year, in December, got R1 billion worth of revenue. There's no greater generation of broadcast deals than India coming to your country, which also means that our players have a significant profile in India through the IPL and through the SA20. What happened in this case is Rario is a company that's been making NFTs, non-fungible tokens on the blockchain, and that market hasn't really taken off. So what they have done is they've moved into fantasy sports. So in other words, you can buy, trade players, which are NFTs, and you can play the game in a fantasy world. And these games are just proliferating in India like you can't believe. The SA20 had about 30, 40 attempts to close down some of these games based on the SA20 and their IP in the last 2 years. But the Delhi High Court went and effectively, where players try to protect their interests, said something which have significant impact on our players, highlighting that publicly accessible information about celebrities or sportsperson, including names and performance data, could not be exclusively licensed and was not subject to infringement claims. So that's a really bad case for us because it's basically saying it's a free-for-all in India. So our player images, their data being utilized in India, and we can't do anything about it. The big plus is that it's gone on appeal, because obviously that impacts some really significant people in India, like Kohli, Dhoni, Tendulkar as well. And those guys you don't want to upset. So it'll be interesting to see what happens in the next year on appeal of this case, but it has a significant impact about our ability to enforce on player image rights and just South African IP around the SA20 and tournaments like that. This digital collectibles. It's not the first case. There was a 2018 case in the States where very similar facts, where similarly the courts there in Indiana said it's newsworthy value, including online fantasy sports operators' use of college names, pictures, statistics for online contests. Newsworthy means that it's in the news, you can use it. The fact that it's all about the player's image and his attributes is irrelevant. It's in the news. So that just shows you some of the struggles you have around trying to enforce in other jurisdictions as well. So our players can do exceptionally well commercially in India. If you travel to India with our Protean players, they can't walk in the street. They can walk in the street here. There it's a different matter. So they have big commercial presences. But cases like this, in terms of use of their image relative to online gaming, etc., is a concern for us. If you get back to South Africa, well, it actually gets a bit boring because we've had no sports cases in South Africa. We really go back to the old-fashioned, I suppose, the old cases, just before I was born, it's very old. 1954 cases where we're talking about individuals who had unauthorized publications of their photograph or they were used in the advert, where the courts have gone and said, well, it's a breach of the personality rights of the individual. It's sort of your standard common law approach, use the acta iniurarum, a general action, right to dignity has been infringed. So we've got a lot of those cases, and if you look at just from a delictual point of view and you look at dignitas being the personality rights, dignity, privacy, and identity. But you can almost see where I'm going with this. It doesn't really help us when we're talking about potential losses and damages that sportsmen and women are suffering. Probably the most significant case we've had, and I think this might be the last case we had in terms of celebrity, but I stand corrected, in 2011, Basetsani Kumali, who was the Miss South Africa TV personality. So she went off to buy a bicycle at Cycle Lab, and busy buying a bicycle, and they recognize her. They say, can we take a picture of you buying your bicycle? So she stands there and take a picture, all happy. And then a few weeks later, I think it was on a Women's Day month, they put a whole advertising campaign about, and there's Basetsani with the bicycle on their advertising campaign. And she says, this is unfair. You've used my identity. And the court finds in her favor, saying effectively, she's entitled to protection against the wrongful use of her image. But the finding there is basically a salarial. It's not a significant amount of money. She had a second claim in that case, which was actually a claim for patrimonial damages of 250,000, but she wasn't able to produce any evidence to prove that she had lost 250,000 or that she had damage to 250,000, because that's actually quite difficult to move into that level. It's easy to say my common law right was infringed upon, my personality right was infringed upon, but to get to the point to say, well, I've suffered damages is difficult, because then we're talking about a delictual claim where you've got to prove a wrongfulness, which becomes difficult in this case. So the judge said, well, you didn't even present any evidence of potential damage, so effectively that's all you get. But that was, I think, the last case we had around that. So we can protect the identity, the privacy, the dignity, but moving into that commercial arena of sort of patrimonial loss, it becomes difficult for us, really difficult for us. We're looking at a type of Aquilian action there. So people often say to me, and players have said to me, is there no other way I can protect my rights in South Africa? What about our intellectual property legislation? Intellectual property effectively is a creature of statute, so surely there's something there. Haven't I got a copyright to my image? Well, not really. Square peg, round hole thing. It's about work, there's a holder. And actually, maybe the holder is the person who took the photograph. That really doesn't fit. Well, can I actually trademark my image? I suppose, and maybe Andre can answer this better than me. In principle, yes, you could. And I think Mandela's actually got some trademarks, which I suppose is appropriate if you're dead, because effectively you don't have the personality right. But how do you enforce a trademark and a Mandela picture when there are thousands of pictures of the individual? So in principle, yes, but actually, what is distinctive about your specific image of you relative to there being 1,000 images of Sia against that image? Maybe if it related to a specific some goods or item, and there's a persistent image, that could be trademarked. So that might work, but really it doesn't work. And that actually came up in this American case, Pironi versus Macmillan. This was the family of Babe Ruth, who effectively tried to enforce all images of him being trademarked. And the court turned around and said, you can't. There are thousands of images of Babe Ruth. You can't go and trademark an image unless it would be something that's a persistent image linked to some type of product. So we can't really look at our intellectual property to take this to another level. It doesn't actually work in that regard. Protection lies in the common law. So as a non-academic, I'm saying, well, the common law needs to evolve. It needs to change with time. That's what the common law effectively is. It's not meant to be stagnant. So we're really saying that within those personality rights that we understand in law, we're actually saying image is part of those personality rights. But how do we move on to that patrimonial loss? That becomes difficult. No one wants to go to court on these things because there's so much uncertainty. And even when we come across infringements, we go and sit with senior counsel and we say, how should we approach this? How should we approach this? And likewise, on the other side, they don't want to go there too. So we're really in this sort of vacuum situation of eyeing each other out. So not necessarily a satisfactory situation. So Monica, it depends. It depends. I just want to finish off quickly with the athletes who are not professional athletes outside the big team sports and the individual sports. Life is difficult. These are very famous athletes in South Africa. They all got medals at our Olympics. But effectively, they are in sporting terms paupers. And part of that's got to do with Article 40 of the Olympic Charter, which basically says that if you're an Olympic athlete, you have no rights around your image. We own it. We take it and we own it and we exploit it and we make hundreds and hundreds or millions. I actually think the Olympic Games is one of the last formal vestiges of formalized slavery in the world, and we're all participating in terms of what happens to these athletes. So the Olympic Games in Tokyo earned $4.2 million, which equates to $370,000 per athlete who took part in the Olympics, and they get nothing of it. Now, you would quite rightly say to me, yeah, but it's damn expensive to put in the Olympics. Yes, it is. It is damn expensive to put in the Olympics. But if you look at the revenue share models around the world of professional sports, and in cricket, our revenue share model is effectively about 32% of CSA's revenue. If you just said 20% of that revenue should go to the athletes who participate, for our athletes, that would be about 1.4 million rand, which would be life-changing to them. Okay. But not only do they get nothing, they can't use their image around the Olympics. And that is a brutal exploitation where athletes are starting to fight back on it. So here's a lovely advertisement image that comes out of the Tokyo Olympics. Coca-Cola, being official sponsor, they've got the right to use the image of the players at the Olympics. So there's Tatiana Schoenmaker, as she was then, and Kaylin Corbett, I think her name is there, two South Africans, in what is a really great picture. It's great. They're getting a diddly spot from that, even though that's going around the world, promoting Coca-Cola. They basically just been exploited there. But Article 40 of the Olympics says that in the Olympic period, you've got no right to your image, basically. So athletes have fought back. Nick Simmons is a well-known American 800-meter athlete. He started a campaign calling Own Your Skin, and what he did when he went to athletic events, he put on temporary tattoos to advertise his sponsors. What the organizers ended up doing was they went around with black tape and they put it all over him to stop him having his sponsorship going out there. So Adam Jamili, just before these Olympics, he's a representative of British athletes. He says, there it is. For most athletes, the Olympics is that one chance every 4 years to be in the limelight. And we want to be able to recognize those sponsors that helped us make the games. We want to attach our image to our sponsors, but we can't. We get exploited. So outside of those big sports where we're talking about our collectives, these athletes actually are exploited to the worst. Just for interest's sake, what the British Olympic Committee did was they then relaxed some of the social media. The IOC relaxed some of the social media requirements on athletes and said, well, if you have an advert that's running prior to the 4th of July this year, you can effectively continue through the games in some form as long as you don't reference the Olympic Games in any way that's not factual, i.e. Steve Johnson, a 2008 Olympic medalist. But you can't go and say you're an Olympic diver. That's totally unacceptable. You can't say that. You can, for example, say thank you to Brand X for all the support, but you can't say to Brand X, thank you, you've been with me every step of the way, a gold medal in Paris. That's prohibited. You get into trouble. You can't say wishing John Doe good luck for his race today. I thought John Doe's race had been run, but wishing John Doe good luck for his race today. That's not allowed during the Olympic period, but you could say proud to sponsor Joe Doe and wishing him all the best for next month outside of the Olympic period. So they've got all these rules to take away the ability to really market. And you might say, so what's so bad about that? If I'm going to give someone 5 million rand and I want to exploit my 5 million rand for that person and their image and their attributes, when are they at their best? When am I going to do that? I want to do it when they're winning Olympics. So the shift in power of athletes is happening slowly. So what happened at this Olympics? Seb Coe gave everyone who won a gold medal $50,000. That is significant. I mentioned it at the Labour Law Conference. It's significant because it's the first time people who win gold medals at the Olympics are actually getting money, because he recognizes his athletes are getting restless and they're going to look for other opportunities because they can't exploit their image. They don't earn prize money. They just get the glory. And the glory is important, but the glory doesn't pay for your coach, doesn't put food on the table. So that's just a bit of an aside. It's a bit of a bugbear of mine, the Olympic Games. What will be interesting is in LA 28, cricket is going to be played. Because the Olympic Committee says, we want to expand cricket into other territories. Absolute bull. Absolute bull. I actually want to hurl when I say that. All they want to do is they want to tap into the Indian market. That's all they want to do. They don't want to go and create new, really. They think we're stupid. But what's interesting, SASCOC doesn't own those rights to the image of the players. We do, in terms of the trust. World cricketers own them at a global level. So they're going to have to negotiate. I see a really interesting fight coming up. Yes, at the Commonwealth Games where the women played last year, we effectively gave them those rights to go and play and to market and that. But this could get quite interesting. And you might very well find that there's some players who say, you know what, I don't want to go. So you might find that the cricket that gets played at the LA 2028 Olympics doesn't have the best players in the world. Because you're getting to the point where the big players, the big boys, and I'm talking about big Indian players and some big South African players, their sponsor will say, we're not that happy that you get sponsored, that you effectively are associated, for example, with Coca-Cola and Toyota at the Olympics. Because we're paying you millions and they're a competing sponsor. And now you're going to go to the Olympics and be sponsored by them. Your image is going to be with them, like Tatiana's was with Coca-Cola. We're not happy. Make a choice. And the player will make a choice and say, you know what, I won't go. This is too important for me. That's what will happen at that level. So, ladies and gentlemen, coming to a conclusion, we've moved rapidly to a place where the image, identity, voice, signature, initials, etc., that we sort of always said our image rights, they have now been enhanced with the story. How did you get to where you are? Crying on TV, your health data, your physical performance, how hard you hit the ball. It's a constant evolving concept, this image right concept. We've got personality rights, as I said, common law must expand, we must go to the image. Specific image rights legislation would be fantastic. If you said to me, what would I like? Let's have some specific image rights legislation. Provide the parameters. What is it? Is it property? Can it be effectively traded and sold? Because that's what's happening. So let the law catch up with the reality and actually govern it a bit. And how do we protect against it? Because that's what one would want to see. And then you need actually the receiver. No one likes the receiver, but you want to be legitimate. You want to do it fairly. You want to pay your share. But if it gets recognized as property and it can be traded and there can be a proper dispensation around it, then the receiver wins and the player wins on all levels. So this is going to change. It's evolving. It's happening. It's very confusing, but you're not going to stop it. So either the legislator sits down and says, let's do something about it, and the receiver, and otherwise it's going to be left to practitioners and lawyers and accountants to try and just create a framework for this to move forward. But it's a fantastic example of something in IP that is sort of not clear, but it's so real. And it's generating hundreds of millions of rands within South Africa in our market and billions of rands in the American market. And it's hundreds of millions of rands in the South African market in a very unregulated manner. Thank you very much.
Thanks, Andrew. It was fascinating to me, and I'm very happy personally. I hope my dean has recognized what you said, that the Indian is the most valuable asset. Oh, you mean the Indian market? The Indian market. Sorry. Andrew has agreed to take a few questions if there are any. So I see Laken has a hand up, and I think I know what's coming your way, Andrew. It might be, a beamer. So I think you might have to take evasive action, but
I can just retire.
I think there's a mic somewhere. There's this mic.
Good evening, sir, and thank you for this. This was incredible. So Andre has handed over the baton to me now. I'm the new kid on the block where it comes to image rights. We did an in-detail dissertation on why personality rights is not sufficient with Prof. Wessel. I don't think he's here tonight. So we proposed in my thesis a draft bill. We actually drafted it. We defined what an image right is using Prof. Klitter, and we looked at the New York right of publicity, taking into account AI, everything that's happening. We drafted a bill. We stated what is an infringement, what is the recourses. We're pushing the bill, actually. But my question is, when I was my examiner, he asked me, why do we want to have statutory protection and not develop the common law? As you saw, the last case was Kumalo, but if the practitioners on your side are not highlighting the actual issue that we have with image rights and all this uncertainty, how are we going to make this issue known?
Yeah, that's a good question, because how do you develop the common law? Well, you have case law that develops it and moves it on. And that, I'm glad you said it was the last case, because that's the last case I found in 2011. So I don't believe we will get there without some type of statutory intervention, purely because no one is going to move forward. There's too much uncertainty. If you sit with a senior counsel on this, and you go to the top senior counsels around this, and they look in the eye and they say, sorry, Monica, they say, well, it depends. And no one's going to, and listen, it's expensive. So no one goes to court on, well, it depends. Okay. So that's not going to happen, that we develop it from a common law perspective through case law and all of that. So we have to look at it from a statutory point of view. The other problem from a statutory point of view is, and I've seen it when you talk to people about this topic, is no one really understands it and sees why there should be a value. It goes to my first point of SEER. No one really recognizes that there is a right there that should be protected, and it's something he owns and he should be able to trade it. It's actually quite, there are people out there who say, we don't agree with you. That doesn't exist. So I think that's a massive obstacle as well, because if someone's going to say to you, counsel or whatever, and I would assume, Andre, maybe you even argued a case on that doesn't exist. How do you move to the next level of creating some legislation around that, where there's even doubt as to whether people who doubt it exist? So I think, I don't know if I'm answering your question, but I think that's part of one of the obstacles we face. And that's why this session is quite important, because there might be people who are saying, I've never thought about this before. I didn't know there's hundreds of millions floating around in South Africa. That's basically unregulated relative to legislation, common law, and from a tax perspective. And maybe it's that knowledge that we need to get out there as to this happens. So your thesis is critically important, because it actually has taken it a step further. But yeah, I don't know if that answers it, but I think it's the perception that, well, why should we? Which is basically what your prof was telling you. Well, just the common law must deal with this. Whereas in America, What's interesting is with the publicity right, it's a common law right there, which over time the states have adopted into statute. And New York was the first one that did it. And then they all sort of followed suit. So suddenly now they've got statute that protects it, which gives them certainty. I suppose maybe the interesting question is what motivated that to happen, to get them to that point. Yeah.
Showing the primarity of English is, as you showed, and that is the stats, social media is creating this platform to recognize English as a full service, really a better way engagement can become much more easily.
Yeah, and they're happening all the time. But having said that, the law is an ass. It's slow to move forward. And that's the problem. If you say that to people in social media, they say, oh, is social media that serious? Isn't it just social media? Where actually you have to get people to believe that it's a business scenario. So even just with Heinrich's example of saying, you know what, you've created a business here, you don't even know about it. You don't even know about it. Oh my word, 400,000 Rand. I didn't know I had 400,000 Rand that I could have exploited there. That's part of the problem. We're at the forefront of that development. The problem is that development's changing all the time. So then we go into NFTs, and NFTs getting traded. NFTs getting traded where the player is getting a cut of the NFT getting traded everywhere in the world. Suddenly becomes very complicated relative to jurisdictions and relative to tax. NFTs have already gone. We're now into metaverse. Metaverse is the next thing. So it's a challenge for the law. How do you keep up with an industry? And it's not just sports people, it's celebrities as well. But yeah, your point is well made.
Any other questions? Owen?
I'm really my comment and ask the question. I agree with you with the way gets some form of statutory protection. Now, an example of where this was done in the past was with the ambush marketing legislation that we passed before in fact, around about the time of the Cricket World Cup. The cricket authorities convinced the government that there was a need to be able to combat ambush marketing because the World Cup doesn't work if you have ambush marketing. And the government then decided to take the bull by the horns and created legislation to bring in ambush marketing. So that is the first prize. If you could contrive a sort of similar kind of situation where with the next Cricket World Cup, ICC says to the South African government, we're not going to allow you to stage this tournament unless you provide adequate legislation to prevent images. That's just a thought I have.
Yeah, sorry, that's a very good point, because that was in 2002, the Trademarks Amendment Act came in to effectively protect against ambush marketing.
Yeah, this is actually the Merchandise Marks Act. Yeah.
It just shows how the legislator can move very quickly.
Absolutely, but you've got to twist the legislator's arm, and that was done at that stage. The other possibility, if legislation is not going to work, is to conduct a test case. If you look at the evolution of our intellectual property law over the last 20, 30 years, there have been a number of instances where test cases have been brought, where you contrive a case. It's a case that has no commercial importance at all, but you want to prove a particular point of law. So you get a situation where the equities are very much in your favor. And you bring that case, forget about damages, that's irrelevant. What you want to do is prove a point of law. And I would suggest that as a possible alternative.
That's why we've got Remingro here tonight to fund it.
But Andrew, I have to thank you. And this is just a small token of appreciation.
Thank you very much.
Of this evening's talk and a little gift.
Thank you very much. Thank you, everybody.
As to that next evolution, if you go up to my office, you'll see there's a folder titled Sport Data, because I see data protection, the monetization of data becoming important. And there has been some US cases on who owns the data. And increasingly, athletes, as you know, are wearing all sorts of devices that collect all forms of data. and for things like fantasy leagues and metaverse games, etc. How does that get monetized, and do they benefit? The athletes benefit from any of this? So I personally I'm looking into that. So hopefully next year, next sports law conference, maybe I might present something on that, or maybe by me saying this year, I'm forced to now look at it. So it's nice to sometimes paint yourself into a corner. But I just want to again make known to the audience here. I know some of your friends, family can't be here tonight, but would have wanted to be here. We are recording it, and as usual, we will upload the video for public consumption. And all that remains for me to do is to thank those whose efforts make an evening like this possible. In no particular order, I must thank some of my colleagues in the faculty who work behind the scenes, people like Kathy and Gerda. And I'd like to thank the Dean and her office for again allocating us a slot in the annual calendar of the faculty. Thanks to Annette, Gretchen and Christine for making the necessary arrangements and for marketing this event via social media, and that's why we have the fantastic turnout we have. As they know, I can be a very demanding and grumpy so-and-so at the best of times, but they have the good graces to overlook my faults and indulge me, maybe to an extent that they really shouldn't. Thanks to the photography team and the video teams, we are of course grateful to Von Seidels for their generous support for this evening and beyond. And in particular, I'd like to single out Bastian and Eric, who unfortunately can't be here tonight, but I must say the relationship is more than a working relationship. Thanks to them, we have delicious food and drink, which our caterer Dilly has prepared for us. Last year, I was foolish enough to suggest that maybe in future, gin and tonic will become the standard pre-drink for the public lecture. I should have known, it was very silly of me, given Annette's endless energy, that she wouldn't think up a new initiative. And she has the ability to outdo herself. And this time she had Laken coming on board with a new pre-drink. So I am no longer going to say that what the pre-drink would be next year, because apparently I am not on point when it comes to trends and stuff like that. So you'll have to come next year to find out what the pre-drink is. Last and by no means least, of course, I have to thank you for attending, for taking time out of your busy schedules. A number of you have traveled from afar. You have spent a whole day with us at the Sports Law Conference, and I know that's a hell of a commitment. A lot of you are practitioners, and I know what sacrifice that takes. So thank you for taking the time to really spend the entire day with us. And so all that remains for me to do is to invite you to the quad to enjoy some refreshments and a drink. Thanks.